January 15th, we're here with Ben Novogrodsky to go over a bill that we passed last year. We did a lot of work on this, and it is H.
H 876 enacted as Act 159, 2024. It's very important.
24. You have the documents on our webpage, committee webpage, and
Sure.
then you can share your screen and bring it up. Just look at the screen.
Print this one, Brian.
So this will lead to a lot of questions, folks. This will lead to a lot of questions. And we're going to have further testimony to go into a little deeper dive in this to really understand our medical care within our current facilities, as well as our MAT program. And there's a few other items that is miscellaneous in this as well. Okay?
I think we were just on the floor yesterday.
Yeah, this is law. This is law.
Kind of refresher, so.
Yeah, just to let you know what's in law. And then we'll be doing deeper dives with DOC on this. But this is to let you know what's in law.
This is, if you click on Wednesday, you're gonna see Ben's, whatever Ben gave us, right there, Act 1.
We'll work with you on that.
Yeah,
So we
I'm
click
sorry.
on,
for the-
You're totally fine.
click on this, the document.
So if folks need help in terms of your iPad, in terms of how to reach documents, I can sit down or Troy can sit down with you and figure it out
And
for that. Because sometimes people want to work with it and sometimes you
Even
don't.
I have the confidence to be able to help.
Yeah, you can help. That's what the vice chair can do.
I got a duty.
Yeah, lots of them. Ben, it's all yours.
All right, thank you, Madam Chair. Ben Novogrodsky from the Office of Legislative Counsel. Good to be back again. So I will be reviewing Act 59, 159 of 2024, which was an act relating to miscellaneous amendments to the corrections laws. So as Madam Chair said, this is in law. This is just a review of what this committee did last year. That made some miscellaneous changes to a bunch of corrections laws, some very substantive, others more technical in nature. So to start off, you'll see in section 1, pages 1 through 3 are only technical changes. You'll see, and for those of you that are new or may have just forgotten, underlined text is added, struck through text has been removed from the law. So you'll see provision of medical care has been added. So all these headings to help with the organization, you'll see going from he or she to a gender neutral term. So the inmate, and these were all the changes that were made on pages 1 through 3 of section 1. Now you get to about halfway through on page 3, and you'll see the new title, pre-existing prescriptions, definitions for subchapter. This is another change that you'll see, which is the term for medication assisted treatment, which is commonly known as MAT. The new term is medication for opioid use disorder, or OUD.
OUD.
Yeah.
That's how I think of it.
So
That's how I think of it. I can't help it.
But I don't know. too.
It's a thing last year.
no, we
Okay.
left it at MAT and
You
we
did.
came back and now it's MOUD.
yeah.
It's OUD now. I still refer to it as MAT because I'll refer to it as something.
Terms change every few years. So
Things
that's
happen.
how it goes.
Legislation you work on now, if you're still here 8 years from now, you'll start working on it again.
That's right. And you'll see, and I probably should have started with that, this section really involves a lot of the medical care of inmates. So this details the different provisions of medical care. Now, I'm not going to go into all of those now. I'm just trying to orient you a little bit. So you'll scroll down farther onto page 3, about halfway down, or page 4 rather, subsection G of section 801 of Title 28 was added, and this is the prescription drug medication that's a part of reentry plans for offenders. Now, it's important to know that there is a difference in the definition of inmates versus offenders. Offenders are those who have been sentenced. So they've been adjudicated guilty of a crime, they've been sentenced, they're under the, and in the custody of DOC. An inmate is anyone, including those, so it could be detainees that are awaiting trial as well. So it's an important distinction because they are different populations. So you'll notice here, this is about offenders, so those that have already been sentenced and are in a facility. So what was done here, and I prefaced this last week, is that there was a mandate established to provide prescription medication to an incarcerated individual that is both available at the facility and clinically appropriate to the offender at the time of discharge from the correctional facility, that the department or its contractor, meaning WellPath, that's the third-party medical contractor, the DOC has, shall provide the offender at release up not less than 28-day supply of the prescribed medication. And not only that, the department shall also provide the offender exiting the facility with a valid prescription. So they're getting at least a 28-day supply of the medication in hand and a prescription itself to redeem once they're in the community and that other supply has been depleted.
So think that through, folks, because this is new for folks. If they're incarcerated and they're due to re-enter the community, they've been sentenced, they've met their minimum. Usually, if you meet your minimum, you're eligible to be released into the community. You could be on furlough, you could be on parole. But once a sentenced offender has reached their minimum, they are eligible for release. They still have, if they have a maximum, they still have to carry that out, which could be in the community. Does everybody follow that? So right now, in our contract with WellPath, WellPath is our provider for medical care, and Isaac, correct me. Anything I say that's inaccurate or not, that it's accurate. Right now, according to our contract that the state negotiated with WellPath, when a person is taking medication within a correctional facility, we're not talking of MAT at this point. We're talking heart, cholesterol, insulin, psychotropic, whatever. It is in the contract that WellPath would provide a 30-day supply, 28 or 30-day supply to the person when they re-enter. The issue we were running up against is sometimes they could leave with the medication physically in their pocket, or sometimes they would leave with a prescription at a drugstore. The issue with the prescription at the drugstore is multifaceted. They may not have dealt with that drugstore for 10 years or 8 years or 5 years of the time they were incarcerated. They would not have insurance to pay for the medication. So even though there's a prescription there, they have no way to pay for it. Or they most likely do not have a primary care provider to go to. So what would happen is they would re-enter a community and not have their meds. And then it puts pressure on your local community because the person could be acting out in burglaries to get money to buy their medication or to find some of this medication. So we are attempting to put in law what the current contract says, but we were very clear that there would be a 28-day actual supply of the prescribed medication, not a prescription, but the supply itself. And then a prescription would follow. Is that accurate?
Yes, that's correct, Chair. We also had a few issues with Medicaid, which is one reason why, with folks who were releasing, restarting Medicaid, which is one reason why we are pursuing the 1115 waiver so aggressively.
We're gonna get into the 1115 waiver. Unless it's another layer.
Don't bring that up yet.
But the real issue is when a person is incarcerated, they lose all insurance coverage. And then with Medicaid, they're not on a pause, they are deleted. So then they have to start the application process all over again. They don't have ID. They may not have stable place of residency. They may not know where to apply or how to do it. They're hanging out there in the community.
Sorry, Chair, the loss of insurance begins upon adjudication or incarceration, not just because they're detained.
On incarceration, so
They still have
detainees,
whatever they had before.
detainees also lose their insurance.
Yeah, it's the federal term, it's inmate of a public institution that's established in the 1965 Social Security Act. It's called the Medicaid Inmate Exclusion Policy. So it's federal law, and it applies to anyone in a public institution who's considered an inmate. Also applies to mental facilities.
Even though perhaps you have not been and will not be found guilty if you've lost your insurance just by that happening. Yeah.
Mhm.
Okay.
It's federal. It's federal.
However, sorry, not to talk about it too much, but the way it works in Vermont right now is that usually, you will receive a piece of mail asking you to re-up your Medicaid coverage. So for a lot of detainees who have very short stays in our system, they might be in there for only a few hours, maybe just a night. And then they either bail out or the charges are dropped or what have you. So there's really no interruption in coverage there. They haven't had any lapse in coverage, but for folks who are in for many months, years, folks who are adjudicated who are in for a while, that's when you see the lapse in coverage. So that's what we're trying to do right now is build a system that will ensure that we can just flip a switch. So folks' Medicaid status will be paused rather than terminated, but we'll get into some of that. But I think to Ben's point around inmate versus offender, we talked about that a lot last year. We'll continue to talk about it, I think, tomorrow and the weeks to come about some of the just operational challenges with detainees in particular, folks who are cycling through the system very quickly, who might be released from court, making it more difficult, for example, to get them their medications.
But we're very clear when we say offender, it is only for sentenced folks. It is not for detainees. We get the 28-day supply. James?
My question's much simpler than this waiver. So not less than 28 days if possible. So that's one question I'm gonna have about what does it mean? I know if possible means, but that doesn't help everybody. Because you possibly might not have. But the other thing is, can people really get insurance restarted, Medicaid restarted, et cetera, in 28 days? I'm sure you guys talked about all this and I'm new
We
to this
did
committee,
the
so-
best we could.
Yeah,
We didn't want them out there for 2 months
No.
with supplies in their pocket.
no, I understand. I just,
And the policy decision that the committee made was the supply plus the prescription,
oh, okay,
right? So to extend it out as far as possible.
I got you.
Yeah.
And also the, if possible, for the 28 supply, give some flexibility to WellPath.
Yes.
too, because they may not have enough on hand, depending how many people are released, because sometimes a release happens pretty quickly. I mean, they could go before the parole board and then they're paroled out the next day, and it happens pretty quick.
But the conventional wisdom is that this reentry process is sort of about a 90-day lead up process, but that can change.
So what type of medication are people on, just so the committee can understand this?
I'd probably defer actually to our testimony on Friday with Dr. Uliger, who's our medical director. He'll probably have more to say on that.
Because there is a lot of medication that's being, I mean, if you think of your own life or your family members, as you start aging, you're gonna start, whether you like it or not, taking some medication. And you see that for folks who are incarcerated. I think we come to the feeling for people who are incarcerated is they don't have any of these issues, that they're healthy and everything is fine, and in fact, their health is in much worse shape.
Mhm.
A 30-year-old coming into an incarcerated setting has a body of about a 50-year-old or worse. So I think the perception on the public's end is these folks going in there are really healthy and they don't need anything, but they're really in tough shape. Really in tough shape. They don't have a primary care provider. They haven't seen a dentist in maybe 10 years.
Forever.
And if your teeth aren't doing well, you've got a lot of health issues as a result of that.
It's not the big buff dudes like in a prison movie, it's reality.
It's reality. It's tough. So are people clear on this language, what we did?
You've got a correction in here on the bottom of page 5,
Has
where
a
it says medication for opioid use disorder. It's already in there.
Yeah.
Oh, didn't we leave it at MAT? We changed it to MOUD last year?
What was your question, Troy?
Just that we're already using MOUD at the bottom of page 5. I don't remember changing from
Oh, we
MAT
did.
to MOUD
did.
statute.
Did,
I just thought that kind of just started evolving, but
no, it was last year. It was towards the end of this. Yeah, we did that.
that's,
The House Corrections Institutions Committee is very on top of it.
we are trendsetters.
That's what our strengths.
There was that AI sheet.
So moving on, there's also another component that the department or WellPath must identify any necessary healthcare provider or substance use disorder treatment, or both if appropriate, and schedule an intake appointment for the offender with the provider or program so that they can continue care once they are in the community as part of that reentry plan. And then the department or its contractor basically may employ or contract with a caseworker or health navigator to assist with scheduling those initial appointments.
The reason we did that is because that time when a person is reentering the community from an incarcerated setting is when that person is more apt to act out. And we were looking at the public safety within a community. And if a person can get their medication and then they can get hooked up with a healthcare provider or a treatment program, they're going to be more successful in their reentry, safer for the community, and also they may not recycle back into corrections. So if you can, that's why we did all that, because the time that they leave a correctional facility, those first few months are the most volatile time where the person could OD, or they could do burglaries or assaults. And we're just looking at the public safety within our communities. And that, in essence, will also help our law enforcement, because then they don't get called out on some criminal activity.
So moving on to section 2. Section 2 has a lot of the same sort of technical updates of terms to offender and updates from MAT to MOUD. So I'm going to scroll past that, but on pages 7 and 8, you'll see a similar concept of what we just discussed applied for MOUD, with some small but important differences. So again, if someone is prescribed the medication as part of opioid use disorder while they're incarcerated, and it's both available at the facility and clinically appropriate at the time of discharge, the department or its contractor WellPath must provide the offender with a legally permissible supply to ensure that the offender may continue taking the medication as prescribed prior to obtaining a prescription in the community. And that language was different because it was decided by the committee that basically you don't want to give these people too much because this medication could be abused, but you want to give them a sufficient supply to stay under treatment. And so legally permissible supply was, after consultation with my health team colleagues, to use there, because that's essentially the amount that would be prescribed by a doctor, so it's legally permissible and can be provided. So that's why there's a difference in terminology between standard medication and medication opioid use disorder.
So what WellPath does right now, by the contract, when someone who is on the MAT program while they're incarcerated, when they reenter, this is a sentence person, WellPath will give them a supply. It could be 2 days, could be 3 days, 4 days, to hold them over before they can kick in to seeing someone either within a hub or spoke provider, so that they can get a prescription to continue on MAT. We don't want them out there in the community with a 28 or 30-day supply of MAT medication. So it's very limited, and it's to make sure it holds them over until they can get into seeing a provider that can then prescribe them continuation on MAT. Make sense? Confusion? Kevin, you look a little confused.
No.
Processing?
My only concern is finding a provider.
Well, that's an issue. That's why we have somebody from Human Services,
We dealt with this a lot upstairs, but in a different vein.
in a different vein, on the other end.
Yeah, well, we made it so that people could buy illegally, like, Suboxone, et cetera. And it would be, you could possess it, but you couldn't technically buy it, but you could possess an illegal amount, et cetera. So there's a whole, you'll learn all the stuff we've done. Yeah, it's very complicated.
And also DOC, and I think through Troy, is going to be offering legislation to, and we're going to get into this in depth next week in terms of how the MAT program operates within corrections, what is used. And then how, when they go out in the community, they have to switch from what is used in the facility
Mhm.
to what is out there in our hub and spoke model. So there's a proposal that maybe we change the type of MAT medication that we use in the facility, but it's a $480,000 cost to do that.
Increase, you mean?
It's a different type. It's with injections.
Right, but it's 400,000 increase over what we already pay.
I can jump in a little bit on that, Chair. So currently in our facilities, we'll talk about this more on Friday, with Dr. Gilliger and Eva, our health director. We use Subutex, which was the first medication we offered back in 2018 with the passage of 176, which is what created the MAT or now MOUD program in our facilities. Subutex is the mono product. So it is just the buprenorphine, just the agonist.
So it's either a tablet or a packet that you put under your tongue.
Yep, right, in tablet form.
And that can be
Currently
drugged.
crushed. Now we are looking at, I don't want to get too far ahead of ourselves here, but we are looking at offering Suboxone now that there's parity in terms of cost. The Suboxone, which is the dual product, which is the buprenorphine and the naloxone.
And that's injectable.
Would be in tablet form.
It would be.
However, we are also interested in, we have had some conversations with members of House of Probes about offering injectable MOUD, the Brixadi injections, which are very expensive, but we're looking at carving out some settlement dollars for that. The benefit being they are not diverted. Right. You can hold folks over for quite a long time. You don't have issues upon release that we might see in cases.
So if you can do the injection, then it helps in terms of the distribution of the medication, because this takes infirmary, it takes medical staff, it takes correctional staff. And it decreases a lot of the diversion.
And other systems are using the injectables.
Yeah.
So the federal system, New York, Massachusetts, New Hampshire are all on injectables.
And it would help in the reentry because it would last a little longer.
Right. It's about $1,500 per dose.
And for those that aren't familiar with the term diversion, that's essentially distributing the drug improperly.
Are there
Or
any-
using it improperly.
And there's a lot of manipulation that can.
Not the way I was understanding.
I don't know if it's a conversation for today or Friday when the doctor's in or a different time entirely, but I don't really know enough about these drugs. I mean, so when you put together naloxone with buprenorphine, do you not get the high anymore? Like I didn't realize people could get high off buprenorphine.
Yeah.
I thought that blocked the same receptors
Yeah.
maybe. So I don't know how they work.
We'll get into that a little bit.
Partial agonist versus agonist.
Yeah,
versus
right.
antagonist.
Yes, yeah, okay.
You know?
Oh, I just was gonna answer that, it's fine.
We'll get into that.
Yep.
So just moving on, you'll also see a couple other provisions to offer care coordination to the offender to expedite access to counseling and behavioral therapies related to MOUD. And then also similar to the medication provision to help identify necessary providers or treatment programs and schedule an intake appointment with those programs or providers to ensure that continuity of care. And again, there can be a caseworker or health navigator to help with the scheduling. So I would say that this is probably the most substantive change that came out of this bill. Are there any questions before moving on to other portions?
Well, that's a very high level. That's what's in law. And on Friday, we'll be doing a little deeper dive because it's a complicated issue. And we also have to get over our preconceived notions. DOC sometimes needs some management tools to deal with the population and the security in the facility. as well as setting folks up. Our mission and our policy for DOC in our statutes is it's rehabilitative. It's not punishment or punitive. So with the policy, the state policy for DOC is a rehabilitation. We can see that in Title 28. It's stated right there in our policy statement for corrections. And you want folks to be able to succeed when they reenter and not come back. You don't want them to come back, and you want them to contribute in a positive way back in our communities. And
And just a little bit of a teaching moment on the difference between identifying session and Green Book law. So when you see a bill, and for instance, here it'll say Section 2, 28 VSA, Section 801B is amended to read, that's a law that's in the Green Books. And that's a law that we're amending. And so these changes will be reflected in the supplements that are added to those Green Books. Now, if you scroll to Section 3, you will see, as I get there, that there is no amendment language, that it's not amended to read. That it's right now, this is going to be session law that you'll find in the white books. And so you'll look up the act number and it'll track this same Section 3 if you're ever interested in doing that. And the reason for this is that, so this was, I'll go into it, but the Joint Legislative Justice Oversight Committee, of which Madam Chair was also the chair this summer, was charged with reviewing earned time within the correctional facilities. Now, since it was sort of a point in time review that was only supposed to take place over the summer during the legislative interim, it's appropriate for session law and not the Green Books, because it's not lasting. It's a point in time thing, so it still has the same force and effect, but it's not worth the cost essentially, and the longevity associated with publishing in the Green Books.
because reality, if it wasn't statute, and you only did this for a few months, then you'd have to come back and repeal.
Right. And you can imagine how large the Green Books would be with all the different reports and studies that are done every year. It would be unwieldy, impossible probably. So just whenever you're looking at a bill and you have any questions, that's a good way to kind of help identify what goes in the Green Books and what doesn't. So with that, let's get into what the Joint Legislative Committee did. So this committee, there was at one point a lot of discussion and some language proposed about expanding the earn time program. Now, I'm sure not everybody understands or knows what earn time is. So earn time is a program within the Department of Corrections that essentially, if you're an offender that's on good behavior, for every month that you're on good behavior, your sentence can be reduced by 7 days.
7 days.
7 days. So that's an incentive, and you can, there's a whole process and procedure about how that works, but that's the important thing as far as the concept itself, is that you earn time off through good behavior. That's kind of the concept. And so there was a discussion about expanding that to include parolees, and also to expand the type of work you can do to earn that good time, to include educational credits. And so, since there wasn't an agreement reached here, it was decided, well, let's have the Justice Oversight Committee look at this over the summer and see if they come back with some recommendations about how to expand it or not. So they reviewed the earn time program, in addition to the operation and effectiveness of the department's victim notification system, because a component of earn time is notice to the victim that an offender might be released early through that earned time. And there's also, what I understand, an interface system where they can go and log in and kind of check on it and look the person up. And there are various interested parties that needed to testify on this: the Department of Corrections, the Center for Crime Victim Services, victims and survivors themselves, and the Department of State's attorneys and sheriffs. And so on November 15th, 2024, the committee decided to submit some recommendations in the form of this letter that I will resubmit to the House Corrections and Institutions Committee and Senate Judiciary, because we're in a new biennium now. But essentially the recommendations were no expansion at this time. And the reason why is because it was very clear from the testimony that the victim notification system was ineffective, clunky, and really problematic. And so there were recommendations to not expand it and to overhaul the victim notification system, potentially even replacing the provider of it, and to also explore if there should be different providers for individuals held pretrial and notifications to victims through that, and those that are held after adjudication post-trial, since, you know, good time would really be affecting them. And does it make sense to have DOC responsible to notify those that aren't necessarily going to be in their custody long-term if they're found not guilty of their offense? So that's something that this committee and the Senate Judiciary Committee,
House Judiciary Committee.
and, yes.
Will be-
Well, no, so just this committee and Senate Judiciary, because they have jurisdiction of,
No, Martin wants to work on victim notification.
well, there's no limit to who can look. I'm just going by who it was addressed to. So are there any questions on what occurred with that?
So we'll get some time to spend with DOC to talk about earned time for that, because there are requirements for that, and there's some stipulation who can get it, who can't. So we'll work.
Yeah, there's a.
We'll have,
Moving target.
it's a moving target.
States.
So moving on to section 4, I had alluded to this last week about the non-driver identification cards, and that as part of reentry, essentially, it was codified in Title 28, what the department and the DMV already do, which is to provide free of charge non-driver identification credentials to people seeking reentry. So the language itself, because it is a little technical, DOC shall inquire with the individual. So ask them who's about to be released if they want to obtain an identification card or any driving credential if they're eligible to do so. And so then there's a little bit of an educational conversation about the differences and costs and all of that. If the individual does want a non-driver identification card, DOC coordinates with DMV and gets it to them free of charge. There is no obligation, because this was a point of discussion last year, to provide driving credentials to these individuals. If they want to pursue that and they're eligible, that is at their own cost. The only thing that will be covered is that non-driver identification card. Any questions on that statutory change? Section 5 was a study committee and report that's actually due today. It was, look at that. To really examine family-friendly visitation within DOC and how it can facilitate greater visitation methods for all inmates who identifies parents, guardians, and parents with visitation rights. This really stemmed from the Lund home. Had a program in the women's facility to facilitate this family visitation. And there was a lot of conversation about expanding that to the male facilities as well. And so to explore that, this study committee was set up to include the Commissioner of Corrections, the Child, Family, and Youth Advocate, a representative from Lund, a Commissioner of Children and Families, and a representative from the Network Against Domestic and Sexual Violence. They had to study those approaches to better family-friendly visitation, including establishing a department policy that facilitates such visitation, assessing correctional facilities' capacity and resources needed to facilitate that visitation, evaluating the possibility of locating inmates at facilities that are closer to family, how inmate discipline can affect family visitation as well, and then examining the current Kids Apart visitation program to help identify ways to achieve parity with the objectives outlined here. Again, more expanding family visitation days and hours, and then consulting other stakeholders on the relevant issues. This report was due today to this committee and the Senate Committee on Judiciary. And you'll see some standard sort of study group language that you'll see many times in the future.
And we're going to schedule this in hopefully next week. To have Kids Apart, the loan come in. I know we're coming. And,
So I will quickly go through the last three sections. The next one is section 6. This was a report to essentially examine over the course of the next year. It's due November 15th of this year. Closing for-profit, private, and out-of-state correctional facilities, so that they are no longer used basically to profit on the backs of prisoners. It's a report that's going to be led by the judiciary and consult with DOC, the Department of State's Attorneys, the Defender General, Law Enforcement Advisory Board, which is a subset of the Vermont Criminal Justice Council, to submit that written report later this year. And the report would identify new laws and amendments, methods to divert individuals away from the criminal justice system, initiatives to keep individuals out of correctional facilities, and an analysis of any financial savings that could result from this. There was a status update that was provided. I don't remember what it was, though.
It's a bit tricky because the judiciary is charged with the report, but the language has to do
See,
provide the
yeah.
update, so.
You know what?
It's okay.
We're not
We're not
perfect.
No.
Okay. Section
Except
7.
Nancy, we're fine.
Well, I'm sorry to disappoint. In section 7 is recommendations concerning reentry services on new correctional facilities that are coming online, specifically the women's facility. So this is a report by DOC and BGS to examine the reentry and transitional services with the objective to transition away and implement modern strategies and facilities to assist individuals involved with the criminal justice system to help them obtain housing, jobs, other vocational experiences, and other services generally needed to reintegrate into society successfully. Also to examine the recommended size of the new women's facility, including the scope and quality of programming and services, to ensure therapeutic, educational, and other specialty design features to support the services that are going to be offered in those facilities, which you'll learn is a focus on reentry and transition back. And then also whether it's advisable to construct a new men's reentry facility, not a correctional facility necessarily, on the same campus as the new women's correctional facility.
we had similar language to that in the capital bill.
And then finally, section 8, you'll probably hear lots of testimony this year about how short-staffed everybody is, including the Department of Corrections. As a result of that, probation and parole officers were needing to staff hospitals when inmates were getting treated there, and that is not normally their job. So they were being pulled from their other jobs to for hospital coverage. And so this was also due today, a plan by DOC and the agency administration to address those staffing shortages, to include staffing recommendations to relieve those PMP officers, the number of staff that's required to adequately relieve those officers, and any of the costs associated with those recommendations. So was that committed today too?
We shall present.
Oh, that's right. That's right. We said present. Well, you're late.
It's time.
So that's it on Act 159.
Thank you.
So that's
Appreciate
real
it.
quick. Thank you, Ben, for the committee. We are back on the floor, but after the floor, let's come back in the committee because I time as a committee to just kind of talk where people are with questions about the capital bill structure and corrections. And I know yesterday you folks had kind of a brainstorming session in terms of some of the issues.
And I have notes to share with them.
That's what I want to go over to. So let's come back here.